This is the latest example of what the forced birth movement is doing around the country, in this case, in Florida.
It is, Lawrence, and I think you've exactly nailed it. There's something just on its face preposterous about a court adjudicating someone too immature to make the decision to terminate a pregnancy and then by default have them be mature enough to bring a child into the world and presumably raise it. One thing that really strikes me in this case, however, is that I've read the order a couple of times from the appellate court. It feels like the judges were kind of trying to do the right thing. They were trying to conform to the judicial bypass law. They were trying to figure out if this teenager, in fact, was mature enough. And what breaks my heart a little bit is that we're living under an old regime where there were other systems to protect, and now we're in this new post-Dobbs regime where nothing matters except that this child will be forced to give birth. And in a weird way, it throws open, and I worry about this so much, every one of these judges looks like a hack now. Everybody looks like a hack. Every judge, we're seeing North Carolina, South Carolina, judges making decisions every day. And this is why we had stare decisis, so that judges didn't look like hacks. Now that it's just kind of a feeding frenzy of choose your own judicial ending, everybody looks partisan, and that is so disruptive for the legitimacy of the court.
Well, they also look cruel. I mean, hacks for me would be the kind description of what these judges are doing. And people in the audience should understand that in an appeals court, the judges never see witnesses. The appeals court never hears this girl's voice. They never see her face. They don't know anything about her. They're looking at paper, and they're making this decision about her life. And they've decided, looking at paper, that she's not mature enough to have an abortion. And at the same psychotic moment, it seems, in their brains, they decide that she is mature enough to have a baby. And they've never seen her to make either one of those decisions.
It's true, and they are deferring to a trial court judge, and the dissenting judge goes through meticulously saying that he thinks the trial court judge kind of gave it her best shot. But you're exactly right. There are so many red flags in this case. The child is in trauma. She says she's in trauma. She has no lawyer. She says her guardian, she has no parents. She says her guardian approves the abortion. The whole thing, as you said, is a handwritten petition. And so, again, she's kind of thrown to the wolves here. And now we're in a world in which she has no recourse. And we should note she's 10 weeks pregnant. At 15 weeks, she can't get an abortion in Florida. So in addition to everything else, the most merciful judge, the dissenting judge, would throw this back to the lower court judge, in which case she starts again and she has 5 weeks to try to get an abortion before the clock runs out. Every part of this feels like it is not centering her. It's centering some value that makes no sense to me.
And, you know, the Supreme Court justices who made this possible, there's not a word anywhere in their opinion that indicates that they care at all, not one bit, about the existence of girls like this. They don't even recognize that these kinds of things happen.
They don't. Girls are invisible to them. Women are invisible to them. Pregnant people are invisible to them. They have this completely fatuous claim in the majority opinion in Dobbs that by throwing it back to the states, this issue just resolves itself tidily and we can all sleep easier at night. And you know who's not going to sleep easier at night is this 16-year-old girl who just, as I said, has no recourse right now. Throwing this back to the states solved nothing, Lawrence. All it did was throw the entire country into chaos and confusion, and in many, many cases, panic and fear.